The United States as well as Washington, D.C., District of Columbia, are privately owned, for-profit, foreign corporations. The United States is a Delaware corporation and is a registered trader on Dun & Bradstreet. Remember, the United States federal corporation is only 10 square miles as established under the Act of 1871. The district was declared and established in the Constitution Art. 1 Sec. 8 Clause 17 in 1787. Since that time, it appears that there have been many incorporation acts establishing corporate governments for the area, including the D.C. Act of 1803 and the City of Washington Incorporation Act of 1819. The D.C. Act of 1871 appears to have been abolished in 1874 and replaced in 1879. The EIN, Employer Identification Number, for the United States Federal Corporation, pursuant to and under Title 28 U.S.C. 2nd 3002 ch. Vi. Part 176 Subpart 15, A, is 16,1906078. The Dun & Bradstreet number for the United States Federal Corporation is 052714196. Guarantee Clause of Art. 4, in which the Supreme Court declined to address whether a state is providing a Republican form of government. Pac. States T&TV. Or. Governments descend to the level of a mere private corporation and takes on the character of a mere private citizen, where private corporate commercial paper, Federal Reserve notes and other negotiable debt instruments are concerned. For purposes of suit, such corporations and individuals are regarded as an entity entirely separate from government. Emphasis added, Clearfield Trust v. United States, 318 U.S. 363 Bank of United States v. Planters Bank of Georgia, 9 Wheaton, 22 U.S., 904, 6 liters. Ed. 24. Supreme Court Annotated Statute, Clearfield Trust Company v. United States 318 U.S. 363, 371, 1942. Whereas defined pursuant to Supreme Court Annotated Statute, Clearfield Trust Company v. United States 318 U.S. 363, 371, 1942, governments descend to the level of a mere private corporation, and take on the characteristics of a mere private citizen. Where private corporate commercial paper, Federal Reserve notes, and securities, checks, is concerned. For purposes of suit, such corporations and individuals are regarded as entities entirely separate from government. What the Clearfield Doctrine is saying is that when private commercial paper is used by corporate government, then government loses its sovereignty status and becomes no different than a mere private corporation. As such, government then becomes bound by the rules and laws that govern private corporations, which means that if they intend to compel an individual to some specific performance based upon its corporate statutes or corporation rules, then the government, like any private corporation, must be the holder in due course of a contract or other commercial agreement between it and the one upon whom demands for specific performance are made. And further, the government must be willing to enter the contract or commercial agreement into evidence before trying to get the court to enforce its demands, called statutes. This case is very important because it is a 1942 case that was decided after the United States Corporation Company filed its certificate of incorporation in the state of Florida, July 15, 1925. And it was decided after the corporate government agreed to use the currency of the private corporation, the Federal Reserve. The private currency, the Federal Reserve note, is still in use today. References: I. Articles of Incorporation of United States Corporation Company, 2, from The Great American Adventure by Judge Dale, retired. Pages 93 to 94. The 4. Corporations are not and can never be sovereign. They are not real, they are a fiction and only exist on paper. 5. Therefore, all laws created by these government corporations are private corporate regulations called public law, statutes, codes and ordinances to conceal their true nature. Do the judge and your lawyer know about this? You bet they do. 6. Since these government bodies are not sovereign, they cannot promulgate or enforce criminal laws, they can only create and enforce civil laws, which are duty-bound to comply with the law of contracts. The law of contracts requires signed written agreements and complete transparency. Did you ever agree to be arrested and tried under any of their corporate statutes? For that matter, did you ever agree to contract with them by agreeing to be sued for violating their corporate regulations? 8. Enforcement of these corporate statutes by local, state and federal law enforcement officers are unlawful actions being committed against the sovereign public, and these officers can be held personally liable for their actions. Bond v. U.S. 529 U.S. 334, 2000. 3. Our government is just another corporation. 50 states tender their resignation from the United States Corporation, Parts 1-4. This may be a major game changer, and trigger major changes of America as we know it. 1. 19 Corpus Juris Secundum, CJS, Corporations Section 886, 2003 Legal Encyclopedia. A corporation is a citizen, resident, or inhabitant of the state or country by or under the laws of which it was created, and of that state or country only. Corporations have a legal obligation to maximize profits. When government becomes a corporation, it ceases to be government, see Clearfield Doctrine, and by becoming a corporator, lays down its sovereignty, so far as respects the transaction of the corporation, and exercises no power or privilege which is not derived from the Charter, U.S. v. Georgia Pacific Co., 421 F.2d 92, 101, 9th Sir. 1970, corporations being fictions from which no law may originate, as no right of action may originate from fraud, invalidating much of the last 100 years of American jurisprudence, both state and national legislation. All revenue now belongs to Admiralty Maritime Jurisdiction, Huntress, and neither for-profit government nor the foreign statute merchant or agent has access to sovereign immunity, even though the agent himself may have been unaware of the limitations upon his authority. See Utah Power and Light Company v. United States, 243 U.S. 389. 409, 391, United States v. Stewart, 311 U.S. 60, 70, 108. Henry Floyd Acceptances, 7 Wall. 666, United States v. Stewart, 311 U.S. 60, 70, 108, Federal Crop Insurance v. Merrill, 332 U.S. 380, 1947. An artificial corporation cannot sue or otherwise contend with a real living man or woman. U.S. Supreme Court, Rundle v. Delaware and Raritan Canal Company, 55 U.S. 14 How. 8080, 1852. Government may also be bound by the doctrine of equitable estoppel if acting in proprietary, for-profit nature, rather than sovereign capacity. The savings to suitor clause is also available for addressing mercantile and admiralty matters, aka civil process at the common law and within a state court, or by removal to federal district court exercising admiralty maritime jurisdiction, in which the state may not hear cases against the state or an agent thereof. Public officials and even judges have no immunity, as officials and judges are deemed to know the law and sworn to uphold the law, and cannot claim to act in good faith in willful deprivation of law. They certainly cannot plead ignorance of the law. Even the citizen cannot plead ignorance of the law. The courts have ruled there is no such thing as ignorance of the law. It is ludicrous for learned officials and judges to plead ignorance of the law, therefore there is no immunity, judicial or otherwise, in matters of rights secured by the Constitution for the United States of America. C. Owen v. City of Independence, 100 South Court 1398, Maine v. Thibault, 100 South Court 2502, and Hafer v. Mello, 502 U.S. 21, Title 42 U.S.C. Sec. 1983. Public officers are merely the agents of the public, whose powers and authority are defined and limited by law. Any act without the scope of the authority so defined does not bind the principal, and all persons dealing with such agents are charged with knowledge of the extent of their authority. Continental Casualty Company v. United States, 113 F.2d 284, 286, 5th Sir. 1940. The 11th Amendment does not protect state officials from claims for prospective relief when it is alleged that state officials acted in violation of federal law. Warnock v. Pecos County, Tex, 88 F3d 341, 5th Sir. 1996. Officers of the court have no immunity, when violating a constitutional right, from liability. For they are deemed to know the law. Owen v. Independence, 100 SCT 1398, 445 U.S. 622, and inadequate training of subordinates may be basis for Title 42 subsection 1983 claim. Maldonado Dennis v. Castillo Rodriguez, 23 F.3d 576, 1st Sir. 1994. Public officers are merely the agents of the public, whose powers and authority are defined and limited by law. Any act without the scope of the authority so defined does not bind the principal, and all persons dealing with such agents are charged with knowledge of the extent of their authority. Continental Casualty Company v. United States, 113 F.2d 284, 286, 5th Sir. 1940. The governments are but trustees acting under derived authority and have no power to delegate what is not delegated to them. But the people, as the original fountain, might take away what they have delegated and entrust to whom they please. The sovereignty in every state resides in the people of the state, and they may alter and change their form of government at their own pleasure. Luther v. Barton, 48 U.S. 1, 12 Led 581. The United States government is a foreign corporation with respect to a state. NYV. Remerriam 36 NE 505, 141 NY 479, affirm 16s.ct. 1073, 41 liters. Ed. 287. 19 Corpus Juris Secundum, CJS, Corporations Section 883, 2003, Legal Encyclopedia. A foreign corporation is one that derives its existence solely from the laws of another state, government, or country, and the term is used indiscriminately, sometimes in statutes, to designate either a corporation created by or under the laws of another state or a corporation created by or under the laws of a foreign country. A federal corporation operating within a state is considered a domestic corporation rather than a foreign corporation. The United States government is a foreign corporation with respect to a state. 19 Corpus Juris Secundum, CJS, Corporations, Section 883, 2003, 19 Corpus Juris Secundum, CJS, Corporations Section 886, 2003 Legal Encyclopedia. A corporation is a citizen, resident, or inhabitant of the state or country by or under the laws of which it was created, and of that state or country only. 19 Corpus Juris Secundum, CJS, Corporations, Section 886, 2003, Njiriangas v. Sanchez, 495 U.S. 182, 1990, at common law. A corporation was an artificial person, endowed with the legal capacity of perpetual succession consisting either of a single individual, termed a corporation sole, or of a collection of several individuals, a corporation aggregate. 3 H. Stephen, Commentaries on the Laws of England 166, 168, 1st Am. ed. 1845. The sovereign was considered a corporation. Seed, at 170, see also 1 W. Blackstone, Commentaries 467. Under the definitions supplied by contemporary law dictionaries, Territories would have been classified as corporations, and hence as persons, at the time that 1983 was enacted and the Dictionary Act recodified. C. W. Anderson, A Dictionary of Law 261, 1893, all corporations were originally modeled upon a state or nation. 1 J. Bouvier, A Law Dictionary adapted to the Constitution and Laws of the United States of America 318-319, 11th ed. 1866. In this extensive sense the United States may be termed a corporation. Van Brocklin v. Tennessee, 117 U.S. 151, 154, 1886. The United States is a great corporation, ordained and established by the American people, quoting United, 495 U.S. 182, 202, States v. Morris, 26 F. Cass. 1211, 1216, number 15747, C.C. Virginia 1823, Marshall, C. J., Cotton v. United States, 11 Howe. 229, 231, 1851, United States is a corporation. See generally Trustees of Dartmouth College v. Woodward, 4 Wheat. 518, 561 562, 1819, explaining history of term corporation. Njiriangas v. Sanchez, 495 U.S. 182, 1990. That compulsion under the natural law does not originate with man, nor with governments formed by men in fictional jurisdictions of corporate legalese drawn in the sand on the ground or on paper by men, in their separate and equal station, but rather with the author of the law. Rightful liberty is unobstructed action according to our will within limits drawn around us by the equal rights of others. Thomas Jefferson 1819. The Law of Agency Michael C. School Middle. Monday, June 11, 2018. The law of agency applies to every level of government in civil law cases. Agency describes situations where one person, the principal, authorizes a second person, the agent, to deal with a third person on the principal's behalf. Agency also comes up in personal injury cases, often when an injured plaintiff sues both the defendant and the defendant's employer under the rule of respondent superior, which states that both a defendant who is working for his employer and the employer are responsible when the defendant employee's negligence causes an injury. When an agency relationship exists, the principal is responsible for any injuries his agent causes while dealing with the third person. These may be physical or emotional injuries or injuries to the third person's financial interests. There are 4 ways to create an agency relationship. 1. Contract. The principal and agent expressly agree that the agent will act on the principal's behalf. 2. Ratification. The agent acts without the principal's consent, but the principal accepts the agent's acts. 3. Estoppel. The agent and principal have no agreement, but the third party reasonably believes they do, and it would be unjust not to let the third party rely on that belief, especially if the principal or agent knew the third party believed agency existed, but didn't try to correct him. 4. Necessity. The agent and principal have no agreement, but the agent has to act to prevent an injury to people or property. An agent has the following duties to the principal: duty to obey the principal's instructions, duty to act with skill and reasonable care, duty to keep the principal informed about the agent's actions, duty of loyalty to the principal, or duty to act in the principal's best interests, duty of good faith when dealing with the principal or a third party, duty to protect the principal's confidential information, and duty to account for any money spent or received while acting for the principal. If the agent fails to perform any of these duties and the principal suffers damages as a result, the principal may be able to win a tort case against the agent for breach of duty. In addition, anyone whom the agent injures while dealing on the principal's behalf may choose to sue the principal for damages based on the third party's injuries. Some courts will hold the principal liable even if there was no express contractual agency relationship, as long as the injured person reasonably believed that the agent was acting on behalf of the principal when the injury occurred. Courts also recognize three different types of agency relationships. 1. Universal agency. The agent can act for the principal in all or nearly all matters. A person who holds power of attorney to act for another person, such as an incapacitated family member, is generally seen as a universal agent. 2. General agency. The agent can act for the principal in a variety of ways, but only for a certain period of time and often only on one project. A general agent's powers are less broad than those of a universal agent, but more broad than those of a special agent. 3. Special agency. The agent can do a specific thing on the principal's behalf, but may not do anything else without the principal's consent. The law encourages principals who discover that their agents are not fulfilling their duties or are acting negligently or recklessly to terminate the agency relationship before the agent lands the principal in hot water by injuring someone else. Check all the tabs on the website, especially the Court Info tab. To avoid a public servant's immunity, you have to notice them.